As USCIS enters 2026 with backlogs still high and scrutiny increasing, the agency is no longer operating with flexibility the way it once did. Officers are being instructed to apply procedures strictly to flag inconsistencies earlier and to pause cases that do not meet technical requirements. This applies across the board: marriage-based green cards, family petitions, employment visas, adjustment of status cases, and even NVC-bound files waiting for consular processing. One of the biggest reasons cases slow down is not because of quotas or visa bulletin movement, but because applications are incomplete or inconsistent at the time of filing. These days, USCIS has increasingly relied on automated intake systems, which means, missing signatures, outdated forms, or mismatched information are being detected immediately. When that happens, cases are rejected or delayed before an officer even reviews the substance. What many immigrants do not realize is that these early delays can push a case back by months, even if the mistake seems small. The second major factor impacting processing timelines in 2026 is how applicants respond to USCIS notices. Requests for evidence and notices of intent to deny are no longer routine paperwork exercises. They are decision points. USCIS officers expect every concern raised to be addressed fully, clearly, and within the deadline. Partial responses or late submissions are now much more likely to result in denials than they were just a few years ago. In a system under enforcement pressure, silence or delay is treated as non-compliance. Biometrics and interviews have also become non-negotiable checkpoints. During the pandemic years, USCIS reused biometrics and waived many in-person requirements. But, that flexibility is gone now. In 2025 and moving into 2026, applicants are being scheduled for fingerprinting and interviews at a higher rate. Missing an appointment without proper rescheduling can freeze a case or even lead to denial. And honestly, even attending unprepared can trigger additional scrutiny and much longer waits. Another issue that is increasingly affecting approvals is eligibility maintenance during the waiting period. Many immigrants believe that once they file, their situation is locked in, but that is not how USCIS operates. Officers actually review eligibility continuously. Changes in employment, unauthorized work, marital status, criminal issues, or even failure to update an address can complicate a case. USCIS has made it clear that compliance is not just required at filing, but throughout the entire processing timeline. And, filing strategy itself is also playing a growing role in how fast cases move. Filing at the wrong service center, choosing the wrong process between adjustment of status and consular processing, or, submitting applications in the incorrect order can all result in delays. In 2026, USCIS is placing more responsibility on applicants to choose the correct path. Mistakes that once resulted in guidance are now resulting in rejections. What ties all of this together is a broader policy direction. Under the Trump administration, immigration enforcement has expanded beyond border control and into legal immigration processes. USCIS is no longer just an adjudicating agency. It is also an enforcement-focused agency. That shift affects how officers view every application, every document, and every response. For families waiting on I-130 approvals, I-485 adjustments, NVC, document review, or visa interviews abroad, the message is clear. Faster approvals are not about shortcuts. They are about precision. Applications that are clean, complete, timely, and compliant are moving. Applications that are not are being paused, questioned, or denied. As 2026 begins, immigration attorneys are advising families to slow down at the preparation stage so they can move faster later. That may sound a bit contradictory, but it really reflects the reality of the system. Rushing a weak case now often leads to years of delay later. On the other hand, carefully prepared cases that follow USCIS rules exactly are less likely to face interruptions. The emotional impact of this shift is real. Families feel the pressure. Workers worry about employment gaps, spouses worry about separation, parents worry about children aging out, and every delay feels heavier when enforcement is tighter and flexibility is gone. But there's also clarity. USCIS has not hidden the rules. They are published, they are enforced, and in 2026, they are being applied strictly, understanding that reality is the first step toward protecting your case. If you are waiting for a green card or visa approval, this is not the year to rely on outdated advice or assumptions. Processing timelines are no longer forgiving. USCIS is watching compliance closely, and small mistakes can carry big consequences. That's all we have for this bulletin. The U.S. Immigration Hub news channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB